Welcome to Transforming Indian Family Court System. Today, we have with us an extremely special guest who is otherwise known as a celebrity lawyer, but unfortunately, I believe that does great amount of injustice to her achievements and accomplishments. We have with us a lawyer who's done and specializes in family law. She practices in Bombay, Bombay High Court, Bombay Family Courts, and all the way up to Supreme Court. And she has more than 2.5 decades of experience of dealing with family law and child custody disputes. She has a published book called Breaking Up: Your Guide to Divorce, which has been extremely well received by the Indian population. So therefore, please join me in welcoming Ms. Mrunalini Deshmukh. Welcome to the program Transforming Indian Family Court System, Ms. Mrunalini Deshmukh. Thank you so much for being with us.
Thank you for having me over on this very special platform and this very special subject, which is about the children and what effect it has on the kids, the warring couples effect on the kids. I think it's a very, very sensitive issue that you have raised, and I must congratulate your sort of organization for doing a human's task in that, because here what you have really done is not to canvass the right of a non-custodial parent as much as a right of a child to be with a non-custodial parent. So I think we are all here fighting for the child's right rather than the non-custodial parent or otherwise. So I think it's a great initiative, and I mean I must applaud you all for doing this kind of thing in today's times.
Thank you so much, ma'am, for your kind words. But diving deep into, one of the things that we found in our survey, which we conducted for more than 500 parents, the video link to which is available in the description below, is a rather worrying statistics for us, which is that 4 out of 5 children walk out of the family court semi-often. That means they lose not just one parent, but lose half of their family, half of their roots, half of the value systems, half of their culture, which obviously we understand has an extremely deleterious effect on the child and the family and the society. Therefore, in your view, what do you think is the key issues, the key problems that are ailing the system? And do these findings really surprise or shock you?
Uh, so, Dr. Kapur, to be very honest with you, having dealt with a lot of these issues, I think what your statistics talks about that half the 4 out of 5 children they step out being semi often or being cut off from the families in which they probably have grown together, and the effect that it has on the children is absolutely so right. That is the reason why I feel that these issues need to be canvassed, to be brought about to the forefront, which is not only a legal issue but also a social issue, a family issue that we are all discussing. That why is it important for a child to have both the parents, unless it's an unfortunate event where one of the parents is no longer there, that means he or she is not alive. That's a different situation. Does it shock me? Does it bother me? It bothers me a lot. It doesn't shock me, and I'm being very honest to you. It may sound a little strange, but I need to be very candid on this. It doesn't. Uh, in my experience in these things is, and of course, and let me be very honest before I make this statement, that today the perception is changing. So I mean, to some extent, I would not say to the extent with which we want, but this perception is changing. And I'm talking for the last 10, 15 years, if I may say, actively, when I was I'm doing all these things, that I have seen that the courts have classically, perception wise, felt that the child has to be with the mother. The father can only see the child at some point of time. So it's like a set norm. Okay, nothing wrong in it. The law also says that up to the age of some certain age, the child has to be with the mother because of the natural affinity and the way the whole naturalization takes place. And that is why the father was also always a visiting father, and there was what was known as a visiting right which was given. So it became like a guest. The moment you say that, Dr. Kapur, you can visit my house, that means you are a guest in my house. You are not my family. So you
True.
understand the concept that how it went about it. So the very fact that you use the word visitation, I think that itself cuts off the tie between the parent and the non-custodial parent. So
Yes.
in all our petitions right now, just to share something of my personal professional part, we discuss and we write parenting time. That the parenting time between the two parents will be divided in this manner. Say Monday to
Yes.
Friday with the father or mother or whatever the case may be, vacations are there. So when you
Yes.
say it's parenting time, it carries with it a lot of responsibilities besides rights to even the non-custodial parent. So a parenting right when a child is, say for example, a child is there with the father over the weekend, it's not only a fun time. The father has to sit down with the child, take him to the classes, take up his or her work, do the projects if there is anything that is to be done. It's just not taking the child out and having fun. So
Yes.
involving non-custodial parent in most cases, which is the father, in doing these things is for the benefit of the child. As we
Yes.
always say, and I always say in a lot of my interviews, etc., that if two people can't get along and if the child has to be there, let the child have two happy homes. So he has one happy home of a mother, he has a one happy home of the father. He knows there's not a tug of war between my father and my mother to pull me here, to pull me there, to influence me or to poison me or do kind of things. Okay, this is the time I'm going to be with my dad, I'm going to study, I'm going to have fun, and, and then I'm going to come back to my mom, and I'm not going to badmouth each other. I'm not going to
Yes.
talk ill about each other or my grandparents or the two sets of grandparents, but I'm just going to have the best time. If this is cultivated in a child, that
Yes.
that this is unfortunate that your parents are separated, but we can make the best of it for the child. And I think we owe it to every child on this planet.
No, absolutely. I think you raised some amazing points. One of them saying, which I would call as reverse gender discrimination against fathers, which was existing, the mindsets. But having coming to that, unfortunately, the problem as I see it is the societal now the society is changing at a much faster rate than our judiciary. Our judicial mindsets are still, if I may say so, still stuck in the 20th century, while we as a society have moved into the 21st century. We are not collecting enough correct divorce rates data. We are not collecting data around children and the impact on them. Therefore, if we need to fasten up this process of changing the judicial mindsets, do you think that it is time for two things? One is, of course, mandatory submission of a parenting plan whenever two parents come into a family court scenario. And second, as I call it, that there should be very clear cut guidelines, whether from the High Court or from the Supreme Court, of saying how should you decide on interim visitation and what is the basic minimum visitation that should be given. Do you think the time has come for these two changes to happen immediately?
Absolutely. In fact, Jatin would also would vouch for it that the Bombay High Court had come with some kind of a parenting plan, and
Yes,
which was given to the lower courts.
yes.
But unfortunately, in some of the cases, and in also those cases where I was sort of one of the lawyers of the party which was there, the court, this is a suggestion of the court, of the High Court. It's not a direction or this is not a law so that it
Yeah,
has to be implemented in that manner. So the courts would say that, yeah, we are aware of it, but this is not the law and this is not the direction of the High Court. That all access matters or visitation matters, as the term is popularly called, has to be done as per the parenting plan which is there. Now, also we have to accept one thing on a more realistic note. I mean, whether whoever is the non-custodial parent, that in most cases it is the ego of the parties. In most cases, it is vengeance against each other. In most cases, it is just to use the child as a weapon to get back to the other person, or whatever the cases may be. Now, these are, in my sense, okay, normal cases that come to us. But there are certain extreme cases also where maybe a non-custodial parent is an alcoholic, whether a non-custodial parent is into drugs, is a substance abuse. And these are the extreme cases which also the courts deal with. So it's not only the normal cases that you and me are talking about, where when both the parents are good, but there's no contact or there's no there's issue between the two of them. So under such circumstances, the courts have always held that we can't use one brush to paint everything, which as far as the access orders are concerned. We as a judge, I as a judge, suppose if I am a judge, I will get into the facts and circumstances of the case. I will understand that, okay, A case is different from a B case because the surroundings are different, the factors are different. Today, the courts, what they are doing is, at least I see that in my Bombay family court, they say we as judges are not going to decide your access. You please go to the counselor and get yours sorted out. Only if it doesn't happen, then you come here. So they are, in a way, I think it's a positive thing, and I'll tell you why I'm saying it's positive. Because they are giving the parties, or the husband and the wife, or the father and the mother, as the case may be, a chance to sit with a third person to help them to come and sort this out amicably, rather than one having an order and the other being affected by the order adversely, or whatever the case may be. So I think that is happening. Secondly, as I would say from my experience from the Bombay courts also, they have the Judicial Academy where the training is given to the judges of the district court and the family court also. Now, in that, besides the procedural part and what the things are to be done, there is also a sensitization which is being done to the judges, especially who deal with these kind of matters. And you will be surprised to know, and this is again purely my experience, so there is no data in that sense of the word, but this is my experiences, that the lady judges who are there in the court are very liberal with the fathers getting their visitation. You'll be really surprised. So you would normally expect that if there is a lady judge, she will side a lady and she will not do that. But they are the ones, in my experience, I've seen, because of course they have their own experience, their own wisdom, and their own way of discharging their duty, where they realize that no, the father should get I'm saying father because don't get me wrong, because most of them are non-custodials are fathers. That yes, the non-custodial should get. Now what happens is, but today, and may I tell you with utmost, I'm a little ashamed of it or a little embarrassed about it. Some of the faculty or the people from my fraternity also have quite a role to play, and I think Jatin will know when I'm saying that, that they have a role to play when it comes to denying visitation to the non-custodial parents. It is me as a lawyer who guides my client who is a custodial parent and who is very disturbed because she is in a very emotionally fragile state of mind, very vulnerable. What do I do? And a lot of responsibility lies on me as a guide, as a lawyer to a custodial parent to see that she is not consumed by her emotions or hatred or revenge and sees a little beyond that for the benefit of the child. So I think it's not only the judges, it's not only the parents, but it's also lawyers who I think have, especially lawyers who specialize in family law. We have a big role to play. Yes, Jatin, sorry, you were saying something, Jatin?
Ma'am, in Family Code Rule 37, the court has to record the reason for appointing an advocate. So similarly, if an advocate for say a number of months or for a number of years, if the access is not being worked out in spite of court orders, then does the court needs to bar the appearance of that advocate in the particular matter
Not
as
really.
amicus curiae?
No. Jatin, though that is the case, what happens is a lawyer represents a client in a court of law for a particular thing. Okay? But behind the closed doors, what is the advice that lawyer is giving to the client? Nobody knows. It's a privileged communication, obviously. A lawyer and a client is a privileged communication. So we do not know what it is. That is why in fact, just yesterday we were having some informal discussion. And I said that the senior lawyers now there are a lot of young lawyers who are entering the profession and who are doing a lot of family law. I myself have juniors who are corporate lawyers but want to do family law also. So I said now the time has come for sensitizing even the lawyers by the Bar Council, by calling senior respectable lawyers from the fraternity to tell them how to deal with these issues with a sensitivity and give the client a correct advice and not an advice to please him or her. Because that's what is the role of a lawyer, to give a correct advice, not to please the client what he wants or she wants. I'll tell you, Jatin, so coming back to your question, sorry, I just derailed a little bit, but coming back to your question, you cannot be holding a lawyer responsible for anything under the Advocates Act because a lawyer acts on the instructions of a client. So ultimately, though you and I may know that a particular lawyer or two, three lawyers are the ones in courts who are, I mean, creating a lot of mischief, we really cannot take that, because ultimately the lawyer is supposed. Suppose if I'm your lawyer, I'm your mouthpiece. I'm doing what you are telling me in a court of law. Now, it may not be necessarily my views, or maybe I'm saying these are your views also, and I'm saying that. But the point is, lawyers act on instruction. So it's difficult to take any action, or should not be taken action against such lawyers, is what I believe.
So, ma'am, do you think that we need to organize parenting workshops for the parents who are involved in litigation? Pre-parenting, I know before the petition is submitted in the court, mandatorily the parent should go for a workshop, parenting workshop, whereby they have been informed or updated about the benefits of shared parenting, a parental alienation having their children, so that they can come to some settlement, some parenting plan in the interest of their own children, rather than going into a litigation.
But can I tell you, Jatin, from my experience as a lawyer in this, when people come to court, or even they come to the lawyers like me, court is the next step. But when they come to me, suppose as a lawyer, by that time there has been so much of distance mentally between the parties. The issues have gone so bad, and that is why they feel the need of coming to a lawyer. For example, the right thing would be, if there are issues, you should go to a child counselor. A child counselor will tell you in an adequate and appropriate manner how a father should behave, how father and mother should behave in the presence of the children, how they should raise the child, disciplining, everything. It's not just having fun, but doing everything which is there, which most of the sensible parents do that in the moment they realize that there are some issues. But by the time they come to us as lawyers, and this is a practical thing I'm saying, there's too much of water that has gone under the bridge, and the whole thing has been vitiated to such an extent that even at that point of time, sending a parent to a workshop, which is a very good suggestion, I'm not against that suggestion, but the minds are so sort of, full of hate and anger and revenge, that whether they would be able to really see beyond that. For example, you are so right. Parental alienation is one of the biggest disease that is there in the family law system, which you are talking about. And this parental alienation, the custodial parent does not realize, holding the child back against his or her wishes not to meet the father or the father's family, is going to be counterproductive to the child. Forget you got your revenge with your husband. You've achieved that. Okay, let's say that. But you are not realizing, as a diligent, dutiful mother, what you are doing to your child, if that is what you are doing to it. I have so many cases at the age of 13 and 14 where a child didn't want to see the father, so called not wanted to see the father, has just rebelled and gone and stayed with the father after 14, because he or she was repressed, was not allowed to say anything. And that repression was only because of the insecurity of the custodial parent, who had the fear of losing the child. So the only thing was to poison about the father and say he's a monster, he's a devil, and you better not go to him. And when the child became 13 and 14 and she realized, no, my dad is not a devil, my dad is not a monster, he's like any other dad, but he was not allowed. And they have just switched over completely. So this also happens. We have seen cases where when children go into depression, they get closed up. They don't talk. The school teachers, why do they have counselors in schools today? Not because children have behavioral issues. That is always there. Some boys are naughty, some boys are mischievous, some children are doing this. It's not only to do this. They have the counselor's role today has to see, because they see a lot of children coming from separated home or broken homes, if I may use that word. And some of them, the parents have irresponsible not to realize what is good for them. And they are able to, very sort of have a perception as to there's some problem with the child. We need to counsel the child, find out and understand what the issue is. This is why today there are all the big schools, all the good schools have their in-house counselors also.
Ma'am, if I may just take you deep into that itself, you raised an extremely pertinent point about parental alienation. Now, if I look at parental alienation, let's look at it from a scenario. Unfortunately, what is happening is we still look at parental alienation as a husband-wife feud where the child has become collateral damage. While you use the right word, it is a disease. It is a form of very severe child abuse.
Absolutely.
Right? Therefore, let's give you a scenario. And I'm just putting you into putting you in a place to say, let's look at how we can solve this problem. Let's say a father, and it could be a parent or any parent, I'm using father, comes to you and says, my child refuses to meet me, although I had a beautiful relationship with my child earlier, but now my child refuses to meet me. The courts, the family courts specifically, have a parents patria jurisdiction. That is, they are supposed to act like parents for the child. The judges are refusing to do anything. In such a case, what would your advice be to this father or this parent, and how would you like to structure the arguments so that the court tends to listen and understand? Because most of the courts today have very, very poor understanding about this disease.
So it's a very pertinent question that you have asked, and I think I will take a little extra time than what is required. Number one, let us understand the practicalities. Today, and let me just sort of limit myself to the family court in Mumbai, because that's where I work more, and I'm sure it must be the same. The burden on the courts today, Dr. Kapur, is phenomenal. If you know, in a place like Bombay, and this is what the statistics have proved, that the maximum filing is in NCLTs and is in family courts. No other courts in Bombay, at least for that matter, or even I'm sure it's true about the other places, where there is a maximum filing which is there. Now, the infrastructure of the court, the support system that the courts have for dealing with these issues. Now, you know that the family courts have been built under a special statute under the Family Courts Act. So there are certain rules, counselors, socio-medical people, etc. All those provisions are there. But now to deal with this, you need to have to give that judge sufficient time. If he has a board of 70 or 80 matters, not necessarily child custody, but all matters which are there, then in such case, it is humanly impossible. Even if you and I were a judge, we would not be able to perform our duties into the best of our ability, despite our passion for what we are discussing right now, or the belief in the matter that we are discussing right now. Secondly, and more importantly, besides the infrastructure law and the volume which is there, I also feel that we could have, at least in family courts, one court which is dedicated to the child custody cases. So that judge does not deal with the other matters. So, and then under that judge, suppose if I am a judge who has been assigned the custody cases for 1 month, I'm not saying forever, say for a month, the assignment should be in that sense. How in the High Court the assignments change, so that should be there. Then under me, I should have 2 counselors who are only dedicated to the child counseling. I should have 2 support systems, which is from, like in the family court, we have a thing called Muskan, which is it's like a paralegal thing, which they also help us to get it done. In fact, I would go in the US. I have done a few cases, meaning I have advised them and things like that. They have a child lawyer also, a lawyer for the child, and the
Guardian ad litem.
Arrangement that is under that if the lawyer is going to charge $100, then as per the financial capacity of the husband and the wife, they have to contribute for the charges. So he's not going to do anything which is, maybe he may charge you very less, but he becomes as an amicus, or he becomes a friend of the court, to be able to really represent what the child is. And then it is within his powers whether he wants to take the child to a counselor, whether he wants to take the child to a play therapy, or he wants to take the child to any other thing which will help him understand what the child wants. Then he can do a home study report of the husband's house, the father's house, the mother's house, his school, find out how the child is doing, and then present that thing to the judge. Because if I'm a judge, how do I know what the child is about? How do I know what is the father's background, mother's background?
That is an amazingly excellent suggestion, and that is something we have been propagating, except that I have 2 slight, very minor differences with what you just said, which is that I believe that it shouldn't be individuals, it should be an institutional body, like CAFCAS, or like in UK has CAFCAS kind of a thing, which should be an independent body. And second, I believe the qualification of the person who is doing this job as a child's advocate should actually be more child psychology related rather than law, because The law is of very little importance in this. It's about human psychology, which
Absolutely.
makes it. Right. So, but I think that's a beautiful suggestion, and that's something which we must make sure. Now, the unfortunate part, as I look at it, is Section 12, Section 10 of the Family Courts Act already provides for it.
Absolutely.
This is one area where we can't blame the parliament or the politicians or the legislator, right? We have to take the blame on the judiciary, because now for the 35 years that powers have been granted to the courts, to the high courts, yet what is it that is stopping them from doing it? Why aren't at least some good progressive chief justices of high courts should implement it like a pilot in India somewhere and see the results?
Yes, as you rightly said, all the sections in the family courts have all the provisions which are there as far as child counselor is concerned, etc. is concerned. But again, as I said, the difficulty which I see as a lawyer going to this court is just the volume and the numbers. Unless we have more courts or dedicated courts to do that, then we cannot do. For example, in the women's laws, you have a domestic violence case. Okay, there are genuine cases of domestic violence also. But then you have some in the family court and you have some in the magistrate's court. So the burden is shared. But today, the family court being the court of original jurisdiction for all custody matters and, of course, visitation matters, etc., is there. The entire burden is falling on family court and they are unable to deal with it. Yeah, Jatin, tell me.
Ma'am, I would still suggest, if parenting plans are prenuptial and postnuptial, they are accepted and made mandatory, it would help a
Yes.
lot in reducing the burdening of judiciary.
So that is what I'm
No,
saying.
I'll just add to that, ma'am, if I may just
Yes.
add to that what he's saying, and I think it's a very right thing. Worldwide experiences, there is 10%, so the volumes increase by mandatory parenting plan. So in
Right.
1 year itself, 10 to 11% decrease in the number and volume of cases filed, which happens. Number one. Number two, see, I come from a medical community. Today we have 0.7 doctors per 10,000 population in India, which is compared to the WHO norms that should be 2. So how do we get around it? We are saying provide a lot more assistance. And the body that you are saying of child psychologists, which we just discussed, takes away a huge amount of load. So even if there are 70 cases, 40 of them are being handled at the psychologist levels, because we all understand creating a competent family court judge is far more expensive than creating competent child psychologists.
Absolutely. How well said. Absolutely. I can completely endorse your views, except that you must understand, Dr. Kapoor, at the end of the day, a family court judge is also a human being. And there is only so much that he or she can do in the given set of infrastructure available in terms of everything, time, etc., available. Now, as far as the parenting plan is concerned, now just to give you a parallel example, now we had all these issues about maintenance. Okay, I'm talking a little different, but I'll give you the example. Either the husband would not come out with the true income, or the wife were earning, but they were earning in cash and they were not coming out, etc. So Justice Indu Malhotra, in her judgment in October 2020, has come out with this that every application which is made for the money, that is the maintenance part of it, either for the mother or I mean for the woman or for the child or whatever, has to be accompanied by an income affidavit of the applicant, and the non-applicant also has to file an income affidavit where all these are. Now, what has happened is now this has become a mandatory thing. Now, it has brought into force that otherwise the non-applicants who are not filing their returns or not coming out clean with their business incomes and so on and so forth are now compelled to do so. Otherwise, they would take serious objections to it. Similarly, at the time of the filing of a custody petition, the first thing that the court should make, in my understanding, suppose the father files or the mother files, to to attach an affidavit that from the parenting plan which has been drawn up, how many are the things that he or she is willing to give. So that, okay, I'm willing to give once a week. I'm just giving an example. I'm willing to give once, whatever. It may be big, it may be small, it may be zero also. But that has to come on an affidavit along with the application. And both the parties have to come. So, what are the common situations that have been agreed upon can be set aside, and those which are the disputed issues could be then sent to a counselor who's dedicated only to do these, parenting issues between the two parties and try and work out something. I'm not saying it's going to yield magical results, but I think we need to take these baby steps to be able to achieve a larger goal, which for which all of us are here this evening. That's what
Ma'am,
I think.
taking that point, one of the issues that I see is the quality of counselors, because we desperately need great counselors. But they are not counselors, they are mediators. They are people who just sit there. Therefore, how can we improve the quality of counselors in the counseling system?
So, Dr. Kapur, it all boils down. Again, I'm going to give you another example. How are the quality of public prosecutors in criminal matters and see the defense lawyers? I mean, we just gone through and seen a lot of these. Just see the difference in the quality. I'm not saying, I'm not undermining anybody. I'm not saying that people have their own limitations. Now, today, as far as the counselors are concerned, in this case, the kind of remunerations that they get, or the kind of sort of salaries, etc., that they get, they are marriage counselors, but their marriage counseling is becomes a very, how do I say, a very clinical job, rather than becoming a little more sort of getting involved as far as the divorces are concerned. But as far as the child custody is concerned, in my understanding, it is inappropriate to send the couple to a counselor. To a marriage counselor. They should send the child to a child counselor to work
Yes.
out the visitation, and then
Yes.
we can have even child counselors who, in the on the roll call, could be visiting people but reporting to the court directly.
Yes.
A visiting faculty, as you have in any of these institutions, so that we
Yes.
have quality people. They may not be paying them, but somebody who wants to do it and who are trained to do it. Today you have a counselor, and Jatin, you will know how things happen in the courts here. The counselor has to deal with the marriage issue, the counselor has to deal with the custody issue, has to deal with the maintenance issue.
Maintenance issue.
It just goes on, and then how much can one person do, and they are not qualified to do that. So if we have a system in place where a court is dedicated to deal with custody and visitation issues, the same court has a counselor who is a child counselor, not a normal marriage counselor, to whom the parties go, and he or she is within her right to conduct any therapies or tests or whatever is required. I'm not too familiar with what they do.
Absolutely.
And take
Absolutely.
the assistance of any external thing within the purview of the act. So we don't want any other remarks on that. And come and directly confide in the judge what he or she has come to the observation. Remember earlier times there used to be this jury system where
Yes.
they used to come, and then the judge used to give a judgment based on what the jury felt. But the jury
Yes.
was a common man's thing, which was what does a common man think about it. But in
Yes.
this case, there could be a specialized person. There could be a team of two people who could do this.
Yes.
This will help the judge also. This will help the court. It will reduce that thing rather than giving some reasoned out judgment as to why father should get twice a week and not four times a week. And this is, I mean, it's really strange the way they have to do it.
Ma'am, the simple answer, as you rightly said, send the child to the child counselor and the parents. Do a simple fit for parenting test. Are these two people fit to be normal range parents? And if they are, institute shared parenting and get on with the cases. Move ahead. But having said that, why is this not happening? I'm just going to be a little provocative right now in saying, because unfortunately, the focus on family law by the Supreme Court and High Courts is very poor. To give you an example, the Supreme Court is supposed to have a family court committee. For the last 3 years, it hasn't met or constituted itself even once. Even once. Therefore, unfortunately, and what I believe is, like I tell everybody, the dissatisfaction with the judiciary is growing significantly, on every day in media and these things. But that dissatisfaction is not coming from these high profile cases. It's coming from these small interactions that everyday human beings or citizens have with the courts. Therefore, if we can start the reforms from the family court system, it will have a ripple effect all across with the satisfaction level. Because one of the things that we found from our survey was more than 85% of people are highly dissatisfied with the judicial system. They are extremely dissatisfied, and that is an extremely troubling sign as I look at it. So, how can we put the focus back on family law within the Supreme Court and the High Courts and
Which
the
is exactly
judges?
what I said earlier, Dr. Kapur, that with a dynamic Chief Justice at the helm of the affairs today as we speak, I think we can use his good offices to highlight this. And someone like your organization, which is doing such a great job, could directly write to the Chief Justice, and I'm sure with his sort of things, he will be able to give you a patient hearing, because he himself may not be knowing all these things. That there is a family court committee has to be appointed in the Supreme Court, and I don't blame him, because there's so many things that they have to do. Nobody is perfect in this world, and nobody is so well read. Now, your organization is doing a very detailed and a focused job on this, and which is what you have brought it out. Honestly, to be very honest, even I did not know that the Supreme Court has a family court committee till you told me right now. I'm being very honest to you. So some things which are there, which you all have done so much of research, you all have done so much of sort of study on this, you are able to bring out all these. Now, if these are the things which have been pointed out, it will not take even say a day or two for the judge to form a committee, and that family court committee could also, they could include the past judges of the Supreme Court also, who have recently retired. It could be a combination of men and women, where they have they are not judges, but this is a committee which is appointed by the Supreme Court, as they have these other committees for other cases, and they report directly to the Chief Justice as far as what their laws, what their recommendations are there for making it a little better and cohesive kind of situation. So I think that could be the first step, as I see right now. But if you go to the family court and tell them to do it, they say, no, we are the court of the first instance. We have no powers. We'll work like this. You get us some orders, you get us some direction, then we do it. So,
Ma'am, yeah,
I just
one more thing.
Yes, sorry.
Yeah, ma'am, one more thing. The other non-custodial parents, especially in Maharashtra, are facing is that when the orders are passed by the family court for especially overnight visits, those orders are getting overturned by the High Court. So, do you think we
Yes.
need a separate division of family court judges in the High Court?
I don't know. I really can't give you an answer to this.
Because this is really a big issue. Majority of the orders get overturned by the High Court, ma'am, especially for overnight and vacation visits.
Yes, I do. I mean, that has been a reality. If you ask me also, what you are saying is not incorrect. That has been a reality. But I really cannot say how the High Court judges should think. Now, what happens is, again, as I said, Jatin, at the beginning of our conversation, it is the perceptions that some of these people have with regarding who is a better parent. Today, their courts are probably aware, but not as aware as they should be, that today a father is as much as a hands-on parent as a mother is, which also means starting from changing the diapers of the child, taking the child to the pediatrician for all these vaccines, etc., taking him, a little grown-up child, to the dentist, etc. And this is all which is done by the father, which traditionally earlier, our generation probably did it, only the mothers would do it and the fathers would just pay the money to the wife to go and do the things done. But today a father is involved right from the day one. Today most of the fathers are in the labor room. The doctors ask the fathers to be in the labor room. One of the reasons is also for them to know that how much difficult it is for a woman to give birth, to sensitize, and to have the joy of immediately seeing the child when the child is out into this world. So in my understanding, what really needs to be done in such cases is that the sensitization of the judiciary to the role of a father in the child, who is not only a provider but who is also a hands-on parent for the child, has to be canvassed in a better manner. Earlier the argument would be that if a girl is 12-year-old, 13-year-old, she can't be with the father because the father will not know what to do with the girl child in the event of a puberty. Today fathers know everything about a child, their own daughter's puberty, how to deal with it, what would be her pains and aches, what are the things that are need to be done, what things to be done. It's not like the earlier fathers that if a child who was in puberty had any issues, the father would never talk about it. Shushu, this is not the thing, it's only for the mother or the grandmother to talk about it. Today we have changed, but the thinking has not changed, to be very honest. We still are in the traditional fold of mind that, okay, 12-year-old is the mother and things can be. I'm not saying who should decide what is the custody. That ultimately the courts, in their own wisdom, in their own experience, and in everything, we do have to agree that they are the courts and they are the final authority. But I think all these suggestions that we are making, I think it's a very constructive suggestion that we are not here sitting and sitting in judgment saying you are wrong, you're wrong, you're wrong. We are trying to come up with suggestions to assist the court. We as officers of the court, you as an organization who believes in the cause that the children should be given all these things. We jointly can do this and assist the court to be able to give what is fair for the child. And again, as I say, in all custody matters, about the right.
So, ma'am, coming to one of the things that you said, this job of even deciding who's a better parent, why should even a judge be required to do that? As long they are normal parents, he or she is not an abusive parent. Why should the courts even be involved in being you're better, you're worse? Number one. Number two, the terms custodial and non custodial parent, that by itself should vanish. At the end of the day, why do we need a concept of saying you have the custody, so you're a superior parent? You are non custodial, so you're an inferior parent. That impacts the child and the society in a big way. But moving on, I want to, because in the interest of time, ask you another topic. I'm just going to shift to, and that is a topic about child interviews within the courts, right? Now, if I look at it, Section 7(1) of the Juvenile Justice Act clearly states child should not be brought to a premises which even resembles a court. Yet, our children are being brought to court, the children of separated parents. Obviously, it cannot be anybody's case that the rights of a child of a separated parent stand at a lower pedestal than the rights of a children who are in conflict with law. And Juvenile Justice Act's preamble clearly states that it is to codify the best interests and welfare of the child, the same principle which applies to family courts, right? Therefore, this kind of an abusive practice of calling children to courts and interviewing them and asking them this question, Are beta, kiske saath rehna? You want to live with your father or your mother? I think that is such an abuse of the child. Why is that not being stopped?
So, Dr. Kapoor, I completely agree with this suggestion of yours that interviewing the child and asking him to choose between the two parents is the worst thing that you can do to a child. To be very honest, not only, but that's the worst thing. I don't think the courts do it in this manner. To be very honest with you, they don't say कि आप जाना चाहते हो नहीं जाना चाहते हो. At least I'm speaking from my thoughts. So this is a very subjective view that I'm giving. I really don't claim to know everything nationally. But some of the cases that we have dealt with in the past, that we have realized that, and of course, the child interview is only with the parent is not there, lawyer is not there, it's only the judge and everything, are not done in a manner the way that you are trying to see. They try to get from the child the background of the parties and their families for them to be able to assess what kind of a background it is and if it has to be there. The wishes of the child is the least of the concern because the courts in 9 out of 10 cases know, if I may use the word pardon, the custodial parent has an influence over the child. And when the custodial parent sends the child from, so I send my child from my house to the court, the child is going to parrot what I have taught him or her, correct? So the courts are very well aware of it. So they do not go by these things that, my dad is bad, I don't want to go, etc. They say you can't say that. In fact, in one of the arguments that I was making, I said instead of making these things The non-custodial parent, the custodial parent should tell the judge, tell the child, if tomorrow you say I don't want to go to school, will I tell you, okay, bunk your school, stay at home, it's all right if you don't study, if you don't educate yourself? I'll be very strict, right? If I'm a good parent, nothing doing. You have to sit in the school bus, you have to go to the school, you have to attend and come there. In the same manner, in the same fashion, this has to be done because it is for the betterment of the child. And this is what I've argued in a court of law. So I'm just sharing this with you on this platform. So that kind of seriousness has to be given to these kind of issues. Now, for the why should the court decide is your first question that you asked me. And I feel that the court should decide because in custody matters, as per the law, the court becomes the guardian of the child automatically. The child is the ward of the court, as they call it. And that is why they are the ones who do take a decision. But to put the entire blame or entire onus on the judge to take make all these decisions is unfair to him or her also because it is probably beyond his or her capacity to deal with so many issues. So this supportive infrastructure, as we've been discussing for the past so many minutes, would assist the court, would not interfere with the court's judgment, or will not interfere with the reasoning of the judge. It will give it a support to be able to reason it out as to why it should be there or not. It could be exceptional cases where the father is good, but sometimes what happens is also, and of course these are the few cases. I would not say that this is a rule, that a non-custodial parent probably, with the hope and with the thing that the child should come to him or her more, does use the parenting time to abuse the other parent and the family member. Now that
Absolutely.
also we have seen. Let's be very honest. And then the
Absolutely.
court cannot allow this. You have to be a responsible person when you have a parenting time with your child. And that responsibility of yours is tenfold than what a custodial parent is. Because you have to spend not only quality time, but you have to invest in the emotions of the child in a manner to make that child into a very natural, bubbly, and a normal child who is not in a tug of war between the two parents and who's been asked whether you want to be with A or whether you want to be with B. So under such circumstances, as much as it is a duty of and again for a lack of better word, I understand you are saying why should you say custodian, non-custodian, but for a lack of better expression for our discussion, that as much
Yes.
as it is the responsibility of a custodian parent to ensure that there is no bad mouthing about the person concerned, it should also be the non-custodial parent's duty and responsibility to ensure that the time given to the child is done in a constructive manner and the child, the father or the mother invests in the child to advantage child.
Ma'am, I completely agree. And I may slightly disagree that the responsibility with the non-custodial parent is 10 times more. But I think I get the point that you're trying to make,
That's the
which is
issue.
to say, as I said, power corrupts and absolute power corrupts
Correct.
absolutely.
Correct.
So whoever has the authority or the power tends to misuse it, which is a very fair point. And I completely agree. Both mothers and fathers are known to alienate the child, and that must stop. And the judges must make sure that that is a message that goes out that this is unacceptable under all circumstances. But I'm just coming to the last bits of our this thing. And obviously, Jatin may have his last bits to ask you, but to simply say, if I were to just ask you to, just put down one, two, three, these are the reforms that can make all the difference in our family court system and which can happen like right now or yesterday, things which can happen, what would they be?
So, as I said, the first thing which will have to be a decision of an admin judge, that is the principal judge, to assign one court which will be dedicated only to the family matters, and to have this infrastructure along with that. So, that counselor which is there, the counselor is only to decide child custody, child visitation, or child custody issue. The counselor should have the liberty to take the help of any private individual or a private professional, but who is directly answerable to the court and not to the either of the parent, to be able to assist in getting understanding the child's mind. Then secondly, it should be also in most cases a home study which has to be done. to be able to find out the background of the parties rather than just go by no, this is there and that is there by the allegations, counter allegation that is. So you appoint the counselor when on a particular day he or she visits the home of the father, visits the home of the father, a mother, and sometimes if required visits the school of the child to find out from the school and things, which is all under the legal sort of guidance, and makes a report independently to be able to say what they. So this is the second, and this I'm saying which is doable. Okay, other things are it will take time to happen, which are the
Sure.
doable part of it. And thirdly, that the child counselors, or the counselor attached to the court should be given the child parenting plan before them and advise the parties or the father and the mother who come that these are the guidelines. They are not the law. They are not this. But out of these guidelines which are there, which are the ones that you are willing to do? But this is what the guidelines are. And then, if there are any disputes or where areas that they are not agreeable, then go to the judge and tell them that we've been able to agree on this, and these are the things that they are not willing. So I think these are the three reforms that we can do it with immediate effect, and in the longer run, as you said, that the family court committee, which is of the Supreme Court, which can be where they will be able to bring about. Now, for example, I'll tell you, you have a lot of these cases. I hope I'll take 60 seconds
Sure.
more. I know we
Please,
have a
please.
time. We deal with so many cases where there are custody issues overseas, and the most of the time it's the mothers. They just come despite the orders of the court. I have a couple of matters where the UK courts have passed orders of the child cannot be removed, etc., or the child is the ward of the court, and they bring the child here, create a jurisdiction for the child and for themselves, take orders protecting themselves without being even a part of it. Okay, you've always been living in Bombay, that's a different issue. You've gone for a short while, then come back is fine. But then you just create a jurisdiction and they say, oh, she's a mother and she's a child and we need to protect. Now, this can happen immediately to give some relief. I understand, because that is, you have to give that comfort to this. But that cannot be the only principle on which you can guide. Then the person who is affected, and in this case, in my case, there was a doctor who was there. The person who was affected, who was armed with an order, because in US and UK, especially because I don't know about the other countries, I can only tell you because I deal with these matters there. Joint legal custody and joint guardianship is a norm.
Yes.
It's not an exception. The parenting time is shared. So and this, but if this is a norm, then that is why they don't want to be fighting custody cases overseas, because here they get better options. You
Forum shopping is happening.
Yes, forum shopping they do, and the forum shopping is only done because they feel there is a nest of comfort over here. But these are all long-term things which needs to be tackled into. There are a whole lot of these cross-border issues which we have dealt also.
Yeah.
But coming back to the first 3 points which I said, if we are able to bring it to these reforms can be done, or these changes, even I don't even want to give it a big name of a reform. If these changes can be done, it will not only reduce the anxiety between the parents, but it will also reduce a lot of burden on the court, who otherwise are sometimes making a speculation based on the arguments without really not knowing. And I don't blame them, because that's the only thing that they can do. That's what I feel.
Wonderful. Yeah. Jatin, sorry.
Ma'am, in some of the cases, Supreme Court has, shifted the custody of the children and put the children to boarding school for, severe cases of parental alienation. But the same action or similar action or change of custody or putting the child to boarding school is not happening by the family courts. So do you think we need some form of mechanism whereby, monitoring by higher courts to the lower court should be done, whereby, periodically records should be called with the number in terms of number of children where, there are cases of severe parental alienation, what is being done about it and what are the steps being taken by the lower courts?
Yes. So for that, again, we need to have an infrastructure in place, Jatin, to be able to ask the court whether a particular child should be sent to a residential school or he or she should be left with a custodial parent in the same. So I cannot say that you can have a blanket formula for that. That will have to be assessed on the facts and circumstances of each case with the expert opinion of the persons concerned, including a child counselor, including any therapist which is there, to be able to find out. But you can't say that you make it as a mandatory thing only to be able to deal with the issue of parental alienation, There are other ways in which you can also deal with the issues of parental alienation, and that can be done in a more constructive way within the same thing. Because sometimes some children are not, I mean, not really very happy going there, or some parents don't want to put it. So these are a little psychological, emotional issues. So Jatin, we can't deal with it in a very clinical manner the way you are suggesting at this point of time. But that could be one of the options that the courts could think of, the way the Supreme Court is saying. But at the end of the day, Supreme Court under Article 142 can do so many things. The family courts have their own limitations and they have to deal with it in a very strict manner. But let's all support the existing courts to bring about internal reforms, which could be, as they say, neutral for both the parents rather than making one as a. And I hope in some day, Dr. Kapur, we get done with this custodial, non-custodial thing. And thirdly, I mean, I strongly recommend we should get done with this visitation, because a child is not a visitor to a father's house or to a mother's house. So we need to incorporate the parenting time as a concept which comes very easily to the judges and the lawyers when they're arguing about, rather than maybe this is a psychological effect, but that will also play a big role in the way the reforms, if they have to be brought about. I think it starts.
No, absolutely.
It starts with baby steps, but that's what we need to do.
No, absolutely, ma'am. Language has a very important impact on the way we think. And calling something parenting time versus visitation can have a huge difference in the way things.
I think.
So,
I think
in the end, if I may just summarize the reforms here, just saying, number one, institute a parenting plan, change the language from from visitation to parenting time, institute rebuttable presumption of shared parenting, and create options for management of parental alienation. That is, give the judges the enough amount of powers and guidelines to do it. And lastly, supplement the judges with an entire body, hopefully, or at least individuals who are child psychologists who can work with the child and ensure that the judges get the right information so they can take an informed decision.
And one last thing, sorry for interrupting you. The court should deal with contempt of access or visitation orders, as we call it, in the
Yes.
same way as they treat if there is a non-payment of money which is done by the husband. So if you are going to put the threat of police, or you're going to put the threat of attachment or something in the and which is right, which is to be done because there's an order of the court, the man has to comply, or whoever has to pay the money has to comply, and you use very aggressive methods to do it. Very good, I support you. Do the same thing for those who are in contempt of visitation orders without any justifiable reason or cause, and because unless that fear of law is put into it, people might tend to take these things in a very light manner, and then you are losing the sanctity of the entire thing. And I think that's one suggestion I would like to make.
No, wonderful. And I think that's an awesome thing that you ended it with, which is to say, as a country, we should focus on the presence of the child with the parent rather than the presence that the child receives from the parent.
Absolutely.
Right?
Absolutely.
Yeah. Wonderful. Wonderful. Thank you so much for your time. Jatin, do you have any last thoughts or comments? No?
No, ma'am has said everything. Thank you so much, ma'am. Thank you.
I think that was wonderful.
Thank you so much, and thank you for inviting me and making me a part of this, because this is something I truly believe, and I do practice that also, what I've said in a lot of these cases. So I really hope we are able to bring about this. We owe it to the society, we owe it to the kids who tomorrow are going to be in the courts in these cases, and I think it's our social responsibility. As far as you and me are concerned, you as an organization and me as a lawyer, we all have to work together to achieve this for the larger good of the children that probably were caught into this sort of, tug of war between the parents.
Thank you so much, ma'am. Thank you so much for all the support.
Thank you. Look forward.
Thank you.